on this Tuesday, September 22nd. We are excited to be here today. We've got a great session planned. I am Robert Theobald, the Small Business Ombudsman and Vice President of Small Business Services here at the Commerce Authority. I want to first start by thanking our community partners. We could not do these boot camp sessions without their support. This is a very small list of all the community partners that have helped out. We've got over 70 community partners that have supported the boot camps. As you notice, today is the 82nd session, so through all 82 of those, we could not do them without their help. So the Small Business Boot Camp and Resource Collective is designed to help small businesses work through the COVID crisis and return stronger than ever. It is a statewide initiative supported by all those community partners from all corners of the state. And the boot camp is going to continue through October, and we will continue to update our Resource Collective as well. So the Small Business Boot Camp and Resource Collective, as I've mentioned, we've done this. Today's the 82nd session. All those previous sessions have been recorded and are available on our website, on the Small Business Boot Camp website. And you can go back and review those sessions, rewatch them if you attended and want to refresh your memory on them. Or if you want to link together certain topics, you can do that as well. You can find them by a week. So great resource. Also on that website, it will have a link to our Resource Collective. And the Resource Collective are the tools and resources provided by our community partners to help small businesses during this period. This is just a simple list of some of the resources of the many that are on there. You can find a guide such as an unemployment insurance guide, a reopening restaurant guide, safe retail, safe recommendations for the construction industry, or a guide to workplace return. Many businesses are still working remotely, but planning to get back into their offices, so those different guides can be helpful. So go on to the Resource Collective and check out many of those excellent tools that are available for you. So this week's topics, we have today's session is 10 mistakes that can hurt your business growth. And then on Thursday, we have basics of financial statements. That's going to be kind of workshop style. It's going to be an excellent session as well. We're looking forward to both of these this week to help all the small businesses out there. So real quick, some updates. Today at noon is our Empowering Rural Communities webinar. Go onto our website, azcommerce.com/rural, and then economic development webinars. Register for that if you're interested. It's going to be a good session. Additionally, the Economic Injury Disaster Loan Program is still active and current. It is a loan program, and it is through the SBA. It's not through your lender, your normal lender, but it is through the SBA. If you've applied but haven't followed up and you're still needing the funds, follow up with the SBA. You need to do that through their customer service number that you can find on their website. And then additionally, we want to share that today starts the SBA's National Small Business Week programming. If you go to sba.gov/national-small-business-week, you can register for the activities and the sessions that they have today, tomorrow, and Thursday. And that is by the Small Business Administration. Also want to throw a quick reminder for the ArizonaTogether.org website. It's the state's COVID-19 information and resource website. Please check that out if you haven't yet. And then also on our COVID-19 page for businesses, our Arizona Business Resources, you can find a lot of information, including links to the different financial resources at the state and local level, and other tools and resources to help your business. Also want to quickly go over some of the programs that the ACA offers for small businesses out there. We have our small business services, and we can help support with navigating to the SBA, through the SBDC with some technical assistance when starting your business. We can share some of the latest developments. Our workforce division can help small businesses looking to hire or upskill their employees with some of the programs that they have. And then our Arizona MEP is a program to help manufacturers grow and develop their businesses. In this time, there's also a lot of people looking to start small businesses or start a side gig, and we have our small business checklist. It's an interactive online resource that helps entrepreneurs identify commonly requested information, both local, state, federal levels. You can see, you know, the different steps you may be in if you're looking to pivot and open up a new direction in your business. There may be some additional compliance items you may need to know about, and this checklist can help you with that as well. So today's speaker, we have Brian Burt from the partner and chair for Emerging Business Group at Snell and Wilmer. We're excited to have him with us and to share his presentation. So Brian, I'm going to stop sharing my screen and turn the time over to you.
All right, thanks, Robert. Let me put my slides up here. All right, can you see that on your end?
Yeah, I can see it in PowerPoint view. There you go. Now it's in presentation mode.
Okay, great. Well, thanks again for the opportunity. I appreciate you and the ACA bringing me in to talk about today's program. I will just go through a real quick introduction. We'll jump right into it. A lot to talk about today. So today's program, how to avoid the top 10 legal mistakes that can hurt your business growth. If you do have some comments and you want to post those on social media, Emerging Business with 1S on Twitter there. Just a little bit of background about those who may not be familiar with the firm. We've been around for a long time, at least by Phoenix standards. We've got about 450 orders in our 15 offices, with Phoenix being kind of the headquarters, and a true full service firm. All the resources you might need to start, grow, and sell your business. Some of the awards we've won over the years. A lot more information available, including a weekly Emerging Business blog that I do. It's really a collection of articles of interest to folks in the entrepreneur community. So if you have a business or like myself, work with small businesses, that may be something to check out. Typically post once a week. Just briefly about myself, I, as Robert mentioned, run our firm's Emerging Business Group, so get to spend my days working with entrepreneurs of all shapes and sizes from a business perspective, and help entrepreneurs from concept stage all the way through to the liquidity event at the back end. Today's agenda, as I mentioned, a lot to pack in, so we're going to move pretty quickly. I'll let you know ahead of time that happy to chat with any of you offline on a free consultation basis to talk about any of the things we highlight in today's program. The full deck in terms of the presentation will also be available after, so feel free to reach out if you're interested, either phone or email, to schedule an opportunity to chat or to get a copy of the deck. So we're going to talk about all these topics today, and we're going to be talking about, in large part, some of the myths on the street. It's a phrase I use to kind of describe things that people get, whether it's from friends, off the internet, etc., that lead them down the wrong path. Lots of these things you may say, hey, why are we spending an hour hearing about these? They seem like common sense, but I can assure you that they come up every day in my practice, sometimes multiple times a day, because people fail to get on that right path and cause substantial harm, if not fatal harm, to the business. And so by looking at each of these issues and kind of looking at where you are in your business and putting those in place, you can save yourself lots of time, money, and brain damage, and hopefully help grow your business as efficiently and cost effectively as possible. I'll also tell you that getting it wrong on the front end is exponentially more expensive when you try to fix it later. If you can fix it, then just do it right in the first place. So for those looking to save legal dollars, and I know that's not at the top of your list as you start and try to grow a company, you're more focused on all sorts of other stuff in terms of hiring, getting the product to market, etc. More fun things. Just a few legal dollars on the front end can really make the difference. So as we go through these, we're also going to highlight some kind of lessons learned, as we'll pack in as many as we can in today's time frame, and kind of real life things that have happened, and you can kind of get a sense of the impact as you take a look at your business. So with that, we'll jump right into number one, selecting the wrong form of corporate entity. We're considering converting if you did, and these are the types of entities that you can select from. A corporation, which comes in two variations. A C Corp is just your standard corporation. Your S Corp is your tax election to be a pass-through entity. And then you have your LLC, your limited liability company. Not a whole lot of LLPs being used these days, so I'm going to skip over that one. All entities offer equal liability protection. So again, our first myth on the street is that you got to be a C Corp to make sure your personal assets are protected. That's simply not the case. If you set it up correctly, that LLC can provide just as much liability protection as any other entity. LLCs, in my opinion, are a great way to start unless there's a reason not to. They offer maximum flexibility, no corporate level tax, so you really have an opportunity to structure it as you choose. Pay only tax at the individual level as opposed to potentially paying two types of tax, both corporate and individual. And there's very few chances there are very few situations that you'll really need to be a public company. If you want to go public, take your company public on the stock exchange. Fewer and fewer are doing that these days, but if that's really the goal at the end of the day, then you will have to be a C Corp, but you can determine down the road if that's the case. There are some circumstances where certain investors will insist on you being a C Corp, but again, that is certainly not the rule. Help clients raise millions of dollars in an LLC structure, and so don't assume that you've got to jump to that automatically in order to make that work for you. Like with almost everything we're going to talk about today, letting the problem fester only makes it worse. So if you said, hey, I think I'm in a C Corp now, and that may not be, may not make sense for me, or I'm in an S Corp, which a lot of accountants will say, hey, start out with the S Corp because there is some withholding advantage on the front end. So there are some tax savings as you start initially. The S Corp makes it really difficult to raise capital given all the restrictions put in place. It may be perfect for you if you're starting your business and you intend to kind of run it yourself, not bring investors in and keep it a fairly small company. But if that's not the case and you plan to grow it and do some other things in terms of employee incentives, et cetera, you may quickly find that the S Corp benefits are outweighed by the restrictions that get put in place. And as you grow the company, should you have to convert from one form of entity to another, the tax consequences can get much worse. And so if you're hearing this today and you say, hey, I want to at least have a second thought about whether we're in the right form of entity, again, happy to chat with you, but waiting only makes the problem potentially worse. So today's first lesson learned, we had gotten involved with a client who, second generation slate of owners. The first generation had formed a C Corp, had passed it to the second generation, and they were still in the C Corp, and we're looking to pass it to the third generation. That's where we got brought in to help. Long story short on this one, they were able to create a new structure using an LLC that would allow the future investors or the future owners, the third group, to get a pass-through treatment. They couldn't do anything about the second level ownership. And so at the end of the day, they had $20 million worth of value trapped in the company that eventually they would get double taxed on when they went to go ahead and sell the company. So it is a tough lesson to learn. They could have elected at least S Corp status long before they came to the table to try to facilitate the transition to third generation. Didn't do that, and now they're really stuck with that double taxation of 20 million. So no matter what the tax rates are, just doing the math on that, that's potentially millions of extra dollars you're going to pay that you didn't need to. Number two, not protecting your corporate shield. So does operating your business out of an entity guarantee personal asset protection? Obviously, the answer is no. Lots of folks will go to the Arizona Corporation Commission, file the articles of organization, articles of incorporation, form your entity, the LLC, the corp, and think that that's it. That's where it ends. And unfortunately, that's not where it ends. You need to make sure you do all the documentation associated with protecting that corporate shield. Always say that you want the worst case to be at the end of the day that you bankrupt your company, but not yourself. And you don't want to do either, but you certainly don't want to bankrupt the company and then have people come after your personal assets. So in order to prevent that from happening, you must prevent what we call piercing the corporate veil. And again, that's just getting through that corporate shield that protects your personal stuff. Three primary ways that can happen. One is not maintaining corporate formalities. So this is something that entrepreneurs do all the time. Again, you set up the company with those articles and you stop there. And you're commingling personal and business bank accounts, and you're not keeping separate books and records, and you're basically treating the company as though it doesn't exist. That's called the alter ego issue, and will allow a creditor to potentially pierce through that shield to get at your personal assets. You've got to treat it as a separate entity. If you're doing business with that entity, meaning you lend money to your company, no problem with that, but you should document that with a note. It doesn't have to be a treatise, just a 2 or 3 pager could do it. It talks about what the payment terms are. When are you paying the loan back? What kind of interest rate are you paying yourself? Same if you are putting money into the company as capital contribution. You're buying into the company, whether it's with equity or otherwise, you want to make sure that's properly recorded. Under capitalization, so starting the company with hopes that revenue will kick in, and racking up obligations, whether it's renting some space, hiring some employees, getting some marketing folks on board to create your website. Again, hoping that revenue kicks in, and when it doesn't, you say, hey, I hoped it will. It would do that. It didn't, and so unfortunately, I'm not going to be able to pay everybody. I feel bad about that, but we're going to have to call it a day and go home. And not starting the company off with enough capital in the bank to be able to pay those initial obligations as they come due is another way that creditors can pierce through that corporate shield. Same thing happens when you go to expand the company. So if you're going into another city and a business, maybe another country, you got to make sure there's enough money in the hopper to fund that expansion. If you are in the middle of operating the company and there's a downturn like we have now, that's different. So, businesses have, dips and so forth with the economy. We're talking about when you start and expand the company, making sure you can pay those debts as they come due. So there's not one amount. People always ask, well, is $1,000 enough? It may be enough. It may be more than you need for your business. In other cases, you may need 50 or 100,000 to get your business started, just depending on what those obligations may be. And fraud. Hopefully no one listening is planning to commit fraud, but what we're talking about here is more of what the courts view as kind of a fraud situation where, for example, you have a non-compete with the company that you just left, and you say, hey, I'm going to start a new company, and let that company compete. So it's not me individually doing it, it's an entity, and so I will be able to circumvent the non-compete by doing that. That's not going to work. Again, you can almost assure that that corporate veil will be challenged in those circumstances. Even if you set up and operate the company correctly, you put all the documents in place correctly, there still can be some personal liability for the things you see on the screen there. We're not going to go into each and every one of these, but I'll pick on a couple of them. One, a personal guarantee. So if you're getting a loan, this is where you might see the guarantee. Sometimes you have to guarantee your office space. Work to get out of that guarantee as early as you can, and don't forget about it. Don't let it go in the background and say, hey, I'll deal with this when we sell the company or when we get refinanced. Keep an eye on that and make sure that you have, when the time comes, that you provide for alternative collateral, maybe another guarantor, or you just get to the point where you're financially in a position that you can get the other party to back off of that. Finally, bad acts. So this should go without saying, but we see it all the time. If you do illegal stuff in your business, that corporate shield is not going to do much to protect you. So lesson learned here, probably one of the saddest ones we'll talk about today, is we had a business. This was back in 2007, 2008, so it seems like an eternity ago. And that individual had grown the company quite well, looking to sell the company, and it was going to be a nice payday, tens of millions of dollars for that owner. Had really worked hard to build the company, and at the same time had millions of dollars worth of personal guarantees, and thought, like many business owners, I'm not going to go through the trouble of working with all of these lenders and others to get off the guarantees. We'll just pay them off at sale time. We're getting plenty of money. Let's just do it all at once. Well, no one predicted, of course, what happened in the fall of 2008 when the market fell out. Unfortunately, that individual and their business they were in kind of a perfect storm. And it took about 60 days for them to go to, vetting term sheets for a huge transaction to zero in terms of what the business was doing in revenue and what the business was worth. They were just in the totally wrong industry at the wrong time and got hit very hard. And so when you know it, those lenders did call in those personal guarantees after the business went under. And instead of, as I mentioned earlier, just bankrupting the company, the individual had to more or less bankrupt themselves. So really tragic tale, and could have been avoided had they got off of those guarantees sooner. Number 3, putting all corporate eggs in one basket. So there's ways to avoid having liabilities that crop up in one company take down the entire company. So lots of different ways to structure this. We do these on a regular basis. And there's a couple of areas where you might think about if, for example, that you have different lines of business that have different risk profiles. You may segregate those lines of business in a couple of different companies. So if one line of business, maybe the riskier one, gives rise to a claim, you're not taking down the entire company. It's maybe only taking down the one company that you do business out of. Another way to break it up is assets. So if you have patented technology or you own real property, you may put that in another company. Maybe you put your building that you own and operate the business out of in a separate LLC, and you lease it to the operating company. In some cases, and some of you on the call may have already seen this happen, the real property ends up being worth more than the company itself, or at least equal value. So something happens in the operating company, customer makes a claim and damage gets done to the operating company, that real property is safely tucked away in that separate LLC, and you can terminate the lease, maintain that real property, and it's not subject to creditor claims. So it really can be a way to protect your assets over time. Once you do have a claim, it becomes difficult to navigate this, and that's the horror story we're going to talk about next. You do have to maintain and respect your own fences. So as I talked about earlier about commingling personal funds and business funds and so forth, you can't do that with multiple companies. If you're going to set them up, you're going to lease your real property or license your intellectual property to your operating business, you've actually got to put in place a lease or a license agreement. You've got to make sure that if employees are used in multiple entities, that there's some documentation in place to cover that. Not difficult to do. Again, entrepreneurs, not big fans of the paperwork, so we can help get you set up and make it fairly user-friendly going forward, but you have to respect those fences. Otherwise, creditors will assume all the companies are essentially one entity. They'll collapse those structures and be able to get at those assets, those lines of business, et cetera, that you were trying to protect. So a quick story on this one. We had a client who had operating company, was building a software product in that initial operating company, intending to take it out and start a new co and be able to go ahead and market that software. That was really kind of the future of what they planned to do. Unfortunately, that didn't happen before a class action claim hit that company, the operating company. And at that point, all the assets of that company become subject to that claim. So you can't just pull the software out, which you'd spend several $100,000 building, and stick it over a new co. If you were to lose that lawsuit, that software would be an asset that the plaintiffs would be able to take in their victory. And so what they had to do in this case was to essentially buy their own software. They could set up NewCo, which we did, and then set up a structure where they bought the software for fair market value at the time, and ultimately would own it in the new company. This one ended on a good note because they settled the lawsuit, and for a period of time, they were just essentially paying themselves. They own both companies, of course, and so no harm done. But had they lost that, they would have ended up paying twice what it would have taken to build the software in the first place. So again, if you're at a situation where you're just starting the company or you're 10 years in and you're in a period where there's not claims, there's not a lot of activity going on, it may be a perfect time to think about structuring your entity so as to protect your assets. Number 4, having no or poor shareholders or operating agreements. So one of my favorite ones to yell at clients about. Why do you need one? Because partners are going to disagree. And if you are in a family business saying, hey, I'm with family members, that won't happen, I can tell you it will happen, and it'll be even more ferocious because they're family members. You have all the business dynamics, and then you layer on top all the family issues, and those are some of the nastiest disputes we've seen. I always say when I give this presentation, talk about this issue, I thought I'd seen everything until we saw identical twin brothers, one of them sue the other one over a partnership dispute. Won't get into that one for all the details for time's sake today, but suffice it to say, all partners are going to disagree. And there is no way that the corporate statute or other laws out there are going to resolve those disputes for you. That's one of those big myths on the street that, hey, we don't have to have one of these if we're set up in a corporation or an LLC. The Arizona statute is going to guide us through. And it's simply not the case. If you go in and read it, it addresses a few issues, but by all intents and purposes, you're left to kind of fend for yourself in terms of how the structure is going to work, how you're going to resolve disputes if you can. And if it's a business dispute, there's no way to easily resolve that. You can't go to a court to figure out which way to expand the business if the two partners are disagreeing. It's a business dispute. It's not a legal dispute. So for all these reasons, it makes sense to create what's essentially a playbook. And I know from having my own experience as a startup owner many years ago and having worked with lots of entrepreneurs since then, that all these things are things folks just don't think about. Again, you're excited to get the business started, to start getting the product to market, again, doing the fun stuff, not thinking about what happens if people disagree. But things happen. People go their separate ways. No one may be looting the company, although oftentimes that does happen. But even if no one's doing bad stuff, people have different expectations about where they want to take the company. They have different understandings of how they want to allocate the management, economic, and other rights. And some people ultimately will want out of the company. Maybe someone dies. Maybe someone just gets bored. Maybe there's a disagreement. And there needs to be an orderly way to resolve those disputes, to pull the playbook out or the rule book out when things are happening and say, hey, back then we agreed that if this situation came up, here's how we would resolve it. And it really will ensure that the company transitions to the next phase without damaging or destroying it. I can't tell you how many times we've seen companies go under when the partners start fighting. Lots and lots of examples that we can give you. For time's sake, I'm just going to go to the next issue. But suffice to say, this is one of the top 2 or 3 issues that people litigate about. And we've got lots of folks here who work on those disputes when it gets to that point. I can tell you, I usually have 3 or 4 on the plate at any given time, and it is always exponentially more expensive to get involved with these battles than it is just to think through the issues and get it documented on the front end. So I encourage you to do that. Raising capital illegally, another favorite topic. I give lots of presentations on this particular issue. I came to Phoenix, as I was mentioning to Robert, about 16 and a half years ago to take advantage of the entrepreneurial environment, and love the city. It really does promote entrepreneurism, and I really want to see people continue to start companies and raise capital. The problem is that people all over the place are doing it illegally. I think what makes Phoenix in part so successful from an entrepreneur perspective is kind of that risk-taking mentality. I kind of call it the Wild West mentality. I'm from the kind of the East Coast, if you will, Midwest and Pittsburgh. And we didn't do things quite like you do here. And that's why we're not doing things back there like you're doing here in terms of starting and growing new companies. The same token, people tend on this topic, for some reason, among all others, tend to wing it, to do the Wild West thing. And I'll give the punchline away on number 5, and that is if you do it illegally, it's a felony. So it's not a good place to be as an entrepreneur. You don't want to get caught up in the federal and state securities rules. And I'm going to give you just a little snippet of what to think about. And like I said, I do lots of presentations on the topic. So if you're thinking about raising capital, I encourage you to attend one of those to get a full kind of in-depth look at how to go through that process. Obviously, happy to chat with you offline as well. But the process starts when you start having conversations. So when you're either sending that first email, you're picking up the phone, you're having that first meeting, you start to become part of that process. And all offerings have to fall into either a registered or exempt bucket. As a startup, you're not going to be doing public offerings. You're going to be raising capital privately. And so the exemptions depend on all these things. And for time's sake, again, we're not going to get into all these details, but suffice it to say that there are today, thanks to the Jobs Act that was passed some time ago now, but some of you may be familiar with that legalize crowdfunding and certain other things. There's lots of different ways to raise capital these days, lots of legal approaches to take to bring those dollars in the door. And every startup's going to need some capital. The question is, which of those paths makes sense for you? And you've got to be compliant at both the federal and state level. And depending on those factors you see on the screen there, how many people you're raising capital from, how many dollars you want to bring in, et cetera, there may be one path available, there may be 5 paths available. And then you have to figure out which path makes the most sense from a business perspective to help increase the chances of success. At the end of the day, there's only 2 agencies that I encourage you really not to tangle with. One is the IRS, which everyone's familiar with, but the other one is the SEC and the state regulators. There's very little tolerance for folks doing this illegally. There's just yet another story in the paper this morning that you may have seen about some fraudulent activity that took place, someone raising capital and going to spend it on all sorts of personal goods and items and so forth. Folks are watching, even though you think they're not, and it's better to play by the rules on this one. We know you're going to cut corners in other areas. You may not set up that alternate company we talked about a couple slides ago, or you may not do that shareholders agreement, but strongly encourage you to play by the rules on the raising capital approach. There are things that you can do these days that you couldn't do when I first got to Phoenix or first started practicing 20 some years ago. There's lots of ways to reach out to people and do some general solicitation where you couldn't just a few years back before the Jobs Act. So people ask, hey, is that crowdfunding in place? It is. Can you raise capital using it? You can. So there's lots of new avenues to go down, whereas I think historically you couldn't do those things, and so people got frustrated and just again kind of did their own approach, their illegal approach, and hoped no one would take a look at it. But these days, like I said, felonies are no fun. And I'll just give you a quick kind of horror story from this one that took place probably about 4 or 5 years ago now. But we, like I said, I do this presentation quite a bit. And sometimes when we're doing it live, people will come up after and say, hey, I've been raising capital illegally, I think, based on what you've been saying. How do I fix that and start to do it the right way? So we did a presentation. We had one gentleman come up and said, hey, I've been raising capital for about 10 years to do some real estate deals, very popular in Phoenix, to buy and sell houses and do other things. He said, I haven't had any issues, but I think I need to come in and chat with you. We said, sure, come on in. We met with him, gave him some homework to think about doing so he could make sure that next offering was compliant. He left, didn't do the homework, but came back with a couple of buddies a couple months later. We gave him the homework yet again and hoped that they would go off and do it. When we don't get the phone call back or we don't see folks again, we know that they probably aren't doing the homework and are probably out there doing it illegally, but happens all the time. So a third call came in a few months after that, and the third time was not the charm. So between the time when that individual had sat and listened to the program, which was probably 6, 7, 8 months between the first to the program viewing and the third call, someone had turned him in because someone in one of the deals was unhappy with what had happened, reported him to the Arizona Securities Commission, and he had gotten, by the time he put that call into me, his third notice of criminal investigation. So first off, you don't wait till the third notice to respond, you respond to the first notice. But more importantly, that's a life-changing type of notification. And so we said, hey, we can set you up with folks here at the firm who can deal with that. That's not me. We've got some white-collar defense folks, and we've never heard from him again. And I mentioned him in these presentations, so I kind of Google him to see if I can locate him. I think he's left the state, never to be heard from again. And again, it just took one individual who was unhappy with what happened in his offering to turn him in and kind of start a process that, again, is not going to end well to the extent you get caught up in it and find yourself having done things that violate the rules. So I encourage you, if you are going to raise capital, to seek some guidance as to how to make sure that's done the right way. Number 6, failing to protect your IP rights. So every company has intellectual property. You might say, I don't have any patented widgets. Well, if you don't, you still have stuff. It may be the brand that you use to market your products and services. Maybe you are in a highly competitive marketplace. There's 1,000 competitors, and the brand that you have behind those products and services are really what's driving the sales. That's why people come to you. It's that customer experience, etc. So everyone has something. It could be a patent. It could be a trademark on that brand, that name, that logo, etc. Or it could be a trade secret. You have some secret formula for doing whatever it is you do that no one else knows, and that gives you that competitive advantage. Going through what we call an IP audit can be an effective way to identify what IP you have, and then the steps would follow. Confirm that you actually own it. So one of those myths on the street, which I understand why this one exists, is if we pay someone to create intellectual property for us. So let's say you hire someone to build a website for you. The assumption is once we get the website and we pay that individual or their company, we should own it, right? That makes sense. And unfortunately, that's not how the law works. It defaults to, if that person's an independent contractor, ownership by that individual. And so it creates a lot of circumstances that surprise people, and they find out the hard way they don't actually own the stuff that they commissioned and paid for. Instead, it sets up a whole host of situations where people get extorted down the road when they find out they need to get that IP under their company's name, and maybe lost touch with, or even worse, are on bad terms with the people who helped them originally. So you want to confirm and make sure that you own IP. If you're dealing with any of the parties, any third parties you see on the screen, there are others, anyone who's creating stuff for you should be subject to a assignment of invention agreement. Very standard agreement. Most employees will sign it, but you also want to make sure folks who are not employees sign something that's equivalent to make sure that, again, you own the work product that you've paid for. Lots of legal and non-legal ways to do this. I think folks are a little bit more tuned to the topic these days with all the data breach and other things going on. So folks are trying to tighten up their systems. Here in Arizona, which is a very business-friendly jurisdiction, you can put in place and enforce confidentiality agreements, non-competes, non-solicits. Lots of folks, again, another myth on the street is that those things are never enforceable, so why do them? In California, you're probably right. There's very strict limitations on what you can enforce there. Here in Arizona, a totally different story, and that's why businesses like to start here, because you do have an environment that promotes protection of what you've created in your enterprise. And so they've got to be properly drafted. You can't pull something off the internet that says people can't compete in a large industry globally for the next 100 years. It has to be tailored to your situation. But if you do it correctly, you can help protect the value that you built. On this one, just a quick story. We had a company we were trying to sell. This was about 12 years ago, and it was the end of the year. It was around Christmas time, and the key component of the business, which was going to sell for quite a bit of money, was the names of the products. The products themselves, not super proprietary. They had some formulas and so forth, but lots of other people competed with this company. It was really, in large part, the brand names that they assigned to those products. Well, long story short, they found out they did not own any of those brand names as they went to close the deal. And so the company who was buying them said, hey, we're not going to pay you, $20+ million in order to buy the company if we don't actually get those names. That's a core part of what we're buying. So we had to chase between Christmas and New Year's people around the world to get those trademarks assigned. Now, this is one of those that ends well. They were still in touch with and still working with those people. They didn't get extorted. We were able to locate them in time and close the deal. But you can just imagine, and I've seen it happen a number of times, where folks aren't in touch and you can't find them, or worse, they aren't on good terms and they extort you for work that you've already paid for, but they know they've got you over the barrel. So they will go ahead and take what they can to help you close your deal. So again, this half sheet of paper that puts in place that assignment can make all the difference down the road. Mismanaging key employee issues. Folks might be saying, not too worried about this. It's a buyer's market these days with so many unemployed. People are happy to have jobs, so I'm not going to worry about this stuff. And definitely not the right tack to take. Lots of people were looking for a new job in 2020. This statistic is obviously stale. I didn't get a chance to update it. I don't know what that number would be these days, but that was before, pre-COVID, when I did this presentation in January. Even then, in good times, and I recall, if you can remember how well the economy was doing in January, everyone's hoping for a great 2020. You still had almost half the workforce looking for a new job. Managing key issues for employees is always important for a variety of reasons. You want your team is probably the most valuable thing you have in the company, and if you don't treat them appropriately, they are going to go find other places to work. Two, when you do things incorrectly from an employment standpoint, it can yield to all sorts of liability. And because of the rules out there protecting employees on the federal and state level, you can find situations where they triple the damages. So instead of owing someone 10 grand for back wages, it's 30 grand. And there can be all sorts of other costs and penalties. There can also be personal liability that attaches for the business owners. So this is one of those places that even if you put the corporate shield in place and maintain that properly, as we talked about, doing things that cause issues for employees and not paying them properly, et cetera, can lead to personal liability for the owners. So you really got to be careful. Ensure that you properly hire and fire employees. That goes without saying. Make sure you understand what they're looking for. Again, you may think you have more latitude these days, but the market will change, things will improve, and people will want to be incentivized to stick with you and do what you need to do to grow the company. Lots of ways to do this. We're finding in the kind of quiet period here, lots of people are putting in place these incentive programs to make sure they attract and retain key employees. As you see on the screen there, you don't have to jump to giving equity, although that may be something you need to do. There's lots of other opportunities like liquidity bonuses and other things that we've seen a lot of interest in over the last 6 months, where people want to give employees an incentive to stay with the company and grow it, give them a piece of the action on the back end, a piece of the pie, as we call it, without having to make them officially owners. So ways to do that and get creative. Happy to chat with some of you about those. Just a few more hot button items. One, every entrepreneur wants to treat its team like contractors and not have to deal with withholdings and payroll issues and taxes and all that stuff. We get it. But just because the two of you decide to make that person a contractor doesn't make him or her so. All sorts of rules on the federal and state level that govern whether that person can be an independent contractor. And if you get caught, and the easiest way to get caught is to have a disgruntled employee turn you in, which happens all the time. And the regulators come in and do an audit and say, hey, here's what we think your team should be characterized as, and can cause all sorts of issues for your company. So getting it right on the front end can be really helpful. Also, determining whether they're hourly or salary. So if you have to bring them on, folks say, hey, if I have to employ them as opposed to making them a contractor, I will make them a salaried employee. I don't have to worry about how many hours I work them. I'm in a startup. Of course, we're going to have a lot of hours going, and so I'll make them salaried. And again, there's rules around that. Those rules have been changing in recent years, and you need to make sure that they are properly qualified as a salaried employee. If not, you can find yourself subject to really expensive hourly overtime wage lawsuits when people say, yeah, I did work 80 hours a week and I never got paid time and a half for those extra 40 hours. So I'm going to come back and oh, that happened over the last 2 years. So you can just do the math and figure out what the damages may be there. These days, it's always been a hot button item. These days, it's red hot in terms of making sure you have a work environment that does everything it can to avoid discrimination, harassment, etc. Those are enormous lawsuits, enormous liabilities for the business, and there are steps you can take to put in place rules and protocols that will help, if something should happen, the business to resolve the issue, contain the issue from a legal liability standpoint, and prevent it from becoming a potentially fatal blow to your startup. You can't prevent someone from doing dumb stuff, although you can certainly encourage an environment that minimizes that chance. But if someone does do something they shouldn't, again, you can put in place policies to make sure it's dealt with quickly and appropriately within the legal requirements. So on this one, for time's sake, I'm going to jump through to the next slide, but just understand that these suits, like anything in the employment area, can be extraordinarily expensive. You can run into seven-figure settlements and lawsuits, etc. Even if something isn't as egregious as maybe it was 5 or 10 years ago, just saying things that shouldn't be said these days can lead to very, very expensive lawsuits that, again, can be avoided if you create a workplace that doesn't tolerate that. Number 8, failing to use commercial contract best practices. And I'm going to try to leave a couple minutes at the end if we can. We'll see from time's sake here. I see we've got one question, so we'll try to address a couple questions at the end if we can. So create and use your own forms. This is one of those places where folks always want to be, well, not be penny wise, pound foolish type situation. They say, hey, I don't want to invest the resources to create my own forms. I'll let the other guys give me their forms and we'll use those. And I do contracts on a daily basis, and it is exponentially more expensive to vet customer agreements from all your customers that you're trying to sell to, as opposed to creating your own form. And so all the folks that you deal with in the business, you probably think about creating a form, and it does a couple things. One, it is much more cost effective. Two, it streamlines the process of implementing it. So instead of having to have someone in the company, maybe it's you, maybe it's someone else, sit there and review from top to bottom every customer agreement that comes in and figure out what we need to negotiate, what's acceptable, what's not. You've got your own agreement that you put out. You know it protects you. You know it creates the terms that are acceptable for the company. And if you need to negotiate a point or two, much easier to do that and much, much, much lighter on the legal fees than to kind of start from scratch in each and every situation. Same goes with others, whether it's vendors, employees, contractors, etc. Want to put in place protocols for reviewing and negotiating. We've seen, and this happens all the time, folks who will spend endless hours on a $5,000 agreement for their company because for some reason they get personally involved in that, attached to it. And you see others where, it could be $1 million customer, and they spend 10 minutes looking at the contract and they go ahead and sign it without really reading it. So putting in place protocols to facilitate appropriate review is important. And know when to call outside counsel. We don't need to be in there reading every contract, especially if you put in place forms that allow you to do your own thing. But you can strategically use your legal resources, cost effectively use those resources to hit issues as they come up, and learn to be self-sufficient when you're negotiating the contracts that you do have. We do standalone presentations on how to negotiate and prepare contracts. So if this is something that interests you, let me know. We'll point you to the next upcoming program. But most entrepreneurs hate to do contract stuff unless you went to law school and decided you wanted to be an entrepreneur. Instead, most people can't stand reading the agreements. That's not something that interests them. And once they see the business deal, they kind of tune out to the rest of the things you see on the screen. Reps and warranties, dispute resolution, all those things get glossed over. And it doesn't take much these days to kill the business if you have a contract in place where there's no damage limitations. And that's one of the big takeaways, is make sure that each contract you sign, you know what the worst case could be. Oftentimes, one sentence can make the difference in the world of where people are concerned about data protection and privacy and data breach, etc. That's become a hot item. So you'll see contracts that say, hey, we represent and warrant that we're secure in terms of the data that we collect from you. And basically, with a sentence or two, you end up putting the company on the hook if there is a breach. And these days, if you paid attention to the claims that are out there, your credit card may have gotten stolen, for example, so you may be sensitive to it. Those claims can easily run in the millions of dollars if your business is breached and sensitive customer information gets in the hands of a third party. And the difference between you being on the hook for all those damages and maybe a potential class action from all the customers that want to sue you now is maybe a phrase or two that mitigates that effect. For example, saying that, hey, to our knowledge, we're not aware of any issues on the data protection front, as opposed to just saying we're good to go. Little phrases can make a world of difference and protect you if the worst case happens. So if you haven't done this yet, I'm actually working on a couple of these today. Think about putting in place forms that will, again, protect the business, streamline the process, and make it a lot more cost effective to deal with the contract issues. Number 9, asking for an unnecessary fight. So anyone who's on the call here has been involved with litigation or arbitration, you know that's expensive and it causes lots of stress and brain damage to be involved with. We've got 100 litigators here in the building that do that every day, and I try to stay as far away from that as I can. I've been involved with a couple clients in those situations and understand kind of what they go through from a emotional, mental standpoint. And oftentimes they say that's worse than the financial toll. Just being involved in litigation over a period of months or years really wears them out, really is stressful on companies, relationships, etc. And so you can avoid these issues, or at least try to mitigate these issues if you understand, train your team to identify the causes. And for time's sake, we're not going to go through each of these, but most of them seem, again, like common sense. You say, well, I'm not going to get emotional about a dispute. Well, that's why people spend hundreds of thousands or millions of dollars fighting about things, because they do get emotional about fights, whether it's partnership disputes or other situations where they think that they've got taken advantage of or they haven't been treated appropriately. That happens constantly. Failure to communicate, which has been made even more pronounced when we're in this virtual era. You miss the ability to see people's reactions and kind of sit down real time and kind of get the data that you would get by sitting in a room with someone and kind of working through an issue, as opposed to dealing with it on email or text or even a video call, where you get some sense of reaction, but it's not the same as kind of sitting down in person. So I know we're limited these days in what we can do with kind of getting together, but encourage you to set up opportunities to communicate live, at least on a phone call, to make sure you're getting feedback as to what's happening. Others I'll highlight. We've talked about the partnership disputes. Those in 50-50 partnerships, that's kind of an ideal, perfect storm for a situation to evolve into an issue, because there's no way to easily resolve those disputes or break deadlocks. Doing business with unethical people is probably one of the top reasons that people get into battles. There's lots of companies that don't do things the right way. They might be very successful, and you may want to do business with them. They may be a great customer for you, at least in theory, but they tend not to follow the playbook in terms of doing business ethically. And as a result, even if you have a good contract in place, they may find ways to get around it, to take advantage of it, or just to try to pressure you into doing things that you didn't sign up for. And so finding people both internally and externally to kind of put on the team and to engage with your company is important. And there's strategies that can reduce your exposure. Again, not going to go through all of these, just highlight a couple for time's sake, but taking informed business risks. You guys take all sorts of risks on a daily basis. That's why you wanted to be entrepreneurs. But taking an informed risk is different than just taking an unknown risk. Make sure you build escape hatches into your relationships, whether it's a consultant you've hired or it's a customer you're doing business with. Make sure there's a way to get out. And understanding what's right for the business may not be kind of sync up with what you can do under the contract. And this is really the case over the last 6 months. People find themselves looking at the contract saying, hey, I can terminate this, or I can take this action because this is the way we drafted it before the virus hit. Well, you may be able to get away with that from a legal standpoint, but that may be terrible for business when that customer goes online and says all sorts of bad stuff about you. So think about whether, again, what you can do legally makes sense from a business standpoint, and kind of proceed accordingly. I always tell folks, kind of draft your agreements to be most protective. You can always be nicer than what's in the contract. You can always go above and beyond, but you can't do the reverse. So you've got to plan for all those potential situations, but give yourself an opportunity to be more generous if the situation arises and is appropriate. Finally, understand that folks do, and these days, because they've been put in really untenable situations, act illogical, irrational. And you may think, hey, the resolution to this issue is X, and why can't they understand that? Why are we going to go fight about it? Why are we going to hire lawyers to go to court? And again, we got lots of folks here in the building that do that on a daily basis, because people don't always act on the other end in the most rational fashion. They get involved with the situation, there's emotion, and they find themselves in a fight that could last for a very long time, and again, be very expensive. So think about that when you're ready to kind of get into battle with someone who you think, and you may be completely in the right, but it may not be worth tangling with that company or individual, you may find yourself wanting to get it resolved and move on with your business. Finally, not planning for a eventual liquidity event. So you guys sacrifice all sorts of things to start and grow your businesses. And I always found it interesting that folks never really plan for the exit. They think, well, at some point we'll sell to a competitor and we'll retire. And they really haven't taken steps to understand how that's going to happen. You know, what's the business going to be worth 10 years from now? And there's typically a way, we won't get into it for time's sake, but we do programs on this as well, where there's typically a way that businesses get valued when you're selling them. And folks never take the time to figure out what their type of business may be worth. And so they plan along the way. Sometimes we've seen companies run for 10, 20 years or more, thinking, hey, if I get to X amount in revenue and X amount in profits, I'll be able to sell the business for Y. And the formula they're using just isn't accurate. Maybe the reality is a third or a fourth or a fifth of what they think they're going to get. And they end up selling the business, and instead of retiring, they go right back to work because the proceeds were enough to pay off the debts and put a couple bucks in their pocket, but certainly not enough to retire on. And that's something they could have figured out a long time ago, but just never took the time to do it. And you also never know, and this is no surprise to anybody this year, things can happen that are completely unexpected. And they continue to happen in 2020. So hopefully your business hasn't been too badly impacted. I know some businesses are having their best years ever because they were kind of perfectly positioned in what they were doing. They didn't know it, but they were. But you don't know when the next crisis is going to hit. And so planning and running your business today as though you're going to have to sell it tomorrow is really the best strategy. And finally, get a regular legal checkup. As I mentioned earlier, happy to give anybody listening a free initial consultation and chat through some or all these issues with you. But things change over time, so I encourage you to go ahead and kind of go through that process, not just once every 10 years. Rules are changing daily, but maybe once or twice a year, just to make sure that what you're doing is consistent with the rules, consistent with best practices, and your documents are taking advantage of the new rules that have come out since you last did that. We host our Emerging Business Seminar Series monthly. Some of you may have been to it. Been doing it for 11 years now. We're virtual for the time being. We've got our next program on how to invest in private companies, similar to today's program. Again, any entrepreneurs are welcome to attend. If you're trying to raise capital, it's good to see it from the investor's perspective. And I've got an updated list of seminars on my little personal website there. So you can check that out at your convenience. It's usually updated once every week or two. So some additional programming opportunities if that's of interest. I think we've got just a minute or two left, so we've got a couple of questions I'm going to pop up and see if we can address those, if we still have time, Robert.
Yeah, we have time. Let's go ahead and address those.
Okay. So one question is, when raising capital to avoid illegal fundraising, setting an accredited investor criteria, but sometimes investors fudge the books. How do small businesses limit their and shield liability against the risk from a few bad apples? So I'm not sure I totally understand the question. I think it relates to investors who are telling you they're accredited, but they're not. And so, there's a new way to raise capital under 506C, and maybe this individual is kind of referring to that. Under that new rule, the investors have to prove that they are accredited. So you have to get written evidence, whether bank accounts or pay statements or other things that could be a letter from a CPA who's seen that person's financials to prove that they're accredited. On the historic approach, which is still the most popular 506B, you're not required to have people prove it per se. The best way to avoid the bad apples, as this person asks, is to, again, know who you're doing business with. And under the historic approach to raising capital, you do need to know the people that you're bringing to the company. You're supposed to have a substantive pre-existing relationship. And so if you have any doubts, better to exclude that person. If they're telling you they're accredited, which is that high net worth standard, $1 million net worth or a couple $100,000 in salary, you need to make sure if there's any questions that you go further and ask ask for additional proof or documentation, or just say, maybe this particular investment isn't for you. Otherwise, you could breach your security exemption and find yourself in all sorts of trouble. Let's see, the second question, are surety bonds, either standing alone or through an insurance policy, required these days in completing small business contracts? Is there a minimum dollar or percentage amount rule? So there's not a requirement in all circumstances. So if it depends on the area, if you're in a construction type situation, then you may need to get certain type of bonds to ensure that you can do the deal. If you're a general contractor, for example, there can be requirements that the project owner puts in place for that. But generally speaking, it's really industry specific. So if you're manufacturing widgets and selling them, and you enter into a contract, you may not be required to have any sort of bond or insurance of any kind. It really just depends on the type of business and the types of relationships you're entering into. So either way, though, I would encourage you, and I'll kind of end with this note if we don't have any other questions, is always look at kind of 3 lines of defense in the business, again, to protect those personal assets. The first line of defense is the contract. So putting in place good contracts that protect you from inappropriate liabilities is your first shield. The second would be insurance. So if you do have a situation where the contract doesn't fully protect you, good to have insurance in place appropriate for your business, your industry, et cetera, to make sure that can kick in and help shield you a little bit as well. And then that last line of defense is that corporate shield. So you have 3 lines of defense. I would set them all up as appropriate to make sure that, again, worst case, you bankrupt the company and not yourself individually. So I think those are the only questions we have. So with that, I think we're out of time. So we'll wrap up. I want to thank everybody for attending. Hopefully you got some good information out of today's program. I want to thank Robert and the ACA for allowing me to present to you. And if you are interested in setting up an opportunity to chat, feel free to let me know. I'm also happy to give you a copy of the deck for reference as well.
All right, excellent. Thank you, Brian. Do you have your contact information again on the slide? I think it was on the previous one.
Yeah, let me just, we'll just back up real quickly here so folks have that.
So again, we want to thank Brian for being on here while he pulls up his contact information. Right there at the bottom of that slide. We appreciate Brian's time. Again, if you're interested in this full slide deck, reach out to Brian. We have a condensed version, which is some highlights on it, available with the recording of this presentation for those who want to go back and review it. But again, thank you, Brian. Great tips. I was taking lots of notes as well, so I appreciate that. And we will wrap up. Just remind everybody, our next session is Thursday morning, 9 a.m. We look forward to seeing everyone there. And everybody have a great day and enjoy your week. Thank you.
Thanks again. Take care.